Good afternoon. Thank you very much for joining BMA Law's series of talks in collaboration with the BMA regarding issues that doctors and practitioners face as part and parcel of day-to-day practice of being within the medical profession. So you're very welcome. Thank you for joining us for our lunchtime seminar. My name is Clayton Williams, and I'm a regulatory criminal inquest and workplace investigator. And I've been a solicitor and I've been in practice since 1997. BMA Law was set up to provide BMA members with services that fall outside of their specific member services as a way of support services to their membership. Such services include provisions practice and other premises issues, dispute resolution, for example, LMC and GP network support issues that arise, but also outside of that, conveyancing, family law, personal injury, litigation, inquests, wills, LPAs, and estate planning. So those are all services that are available at discounted rates for BMA members. And if you ever want any further information in relation to that, do not hesitate to have a look at our website at BMA Law or contact one of the lawyers or support service staff that are available for contact details on the email. The other point I just wanted to make reference to, which is available to BMA members, is the doctor support service. And that ties in quite neatly with the talk that we're having today in relation to regulatory practice and proceedings. So if ever you feel that you need confidential and emotional support for matters that you're going through in terms of fitness to practice procedures or other issues that you're having, it's free, and it's also open to members at an email address, which I'll read out to you, and I'll come back to it later in the seminar. It's doctorsupportservice@bma.org.uk. And their telephone number is 020-7383-6707. I'll repeat those towards the end of the seminar, and obviously those details are available to you on the BMA website. I think from the outset, in relation to this discussion about the power of the regulator, I think I just want to make it clear that, in fact, the statistics of doctors appearing before a medical practitioner's tribunal is very low indeed. It's only 0.07% of the doctor population who appear before the tribunal. So I think from the outset, I want to say that the figures are encouraging and low, but of course, it's important that practitioners are aware of what would happen if the General Medical Council ever darkened your door and started an investigation against you. I think from the very outset, I would say to you that you need to reach out to support services if you ever find yourself a recipient of a letter from the GMC. Because obviously that is an extremely difficult time in any practitioner's life. Nobody, whatever profession they're in, want to be referred to the regulator because it's a particularly emotional and potentially professionally embarrassing moment. But by virtue of being a professional, by virtue of being in the privileged position of being a doctor, you are regulated. And that's the difference between us fellow professionals and people in other walks of life. And so it's important that you have an opportunity to understand the process. So if, as I say, you ever find yourself being contacted by the GMC, then my first piece of advice is to reach out to your defence service immediately. And I appreciate that many of you will be members of other organisations who will provide that service to you. And we're not here to dissuade you in any way from doing that, because you have to do what's absolutely right for you. And when membership, for example, of other defence organisations provide you with legal protection in relation to those proceedings, then of course you must access those straight away. We do offer this. We offer the service at BMA Law. So quite often we will have members who might be in other defence organisations, but the issue for which the GMC is investigating may not fall within their membership. So quite often, for example, other defence organisations will not cover the member for matters that arise outside of clinical proceedings. So you check the terms of your membership, check the terms of your indemnity, but you know that we are here as well to provide that service if the need should arise. So the first stage of the GMC will contact you. Of course, a member may contact the GMC first, which is the right and proper course if you find yourself in a situation either through a workplace clinical matter or matters that arise outside of work, for example, criminal allegations or family domestic allegations or other type of proceedings. Quite often those matters should be referred to the GMC. There's not a blanket throw over this. You need to check, first of all, if what you're going through does actually need to be referred in the first place. So don't feel that anything that occurs in your life needs to be referred to the GMC. That needs to be carefully considered by your lawyer. So that's a second piece of advice, really, to establish, first of all, if the situation that you find yourself in at the time, for example, it can be a police investigation before charge, you need to speak with one of your representatives to make sure that that does at that point need to be referred to the GMC, or whether it should be referred to them later on. So I think it's all about remaining calm under pressure. It's very difficult when you're contacted by the regulator, but the temptation quite often with doctors is because they're good people, they want to do the right thing, and there's always a temptation sometimes to overshare. So it's essential that whenever you're contacted by the GMC that you reach out to representation first and foremost, and don't attempt any communication with them alone, is my advice. So the scope, of course, for GMC issues is wide and can include conduct matters such as police investigations, but there's a breadth of issues that they deal with, including clinical issues to conduct, such as I previously mentioned, family proceedings. The GMC provides guidance for doctors, which is under the good medical practice, and that outlines the standard of professional conduct that the public expect from its doctors, physician associates, and anaesthesia associates. And it was updated last year in 2024, and their keystone is to ensure that patients are cared for properly, that there is a good standard and practice of care, and that you are working with competence, and that you are treating patients and colleagues with respect, honesty, and integrity. So that was the overhaul in the good medical practice guidance last year. It's pretty straightforward, really, and it's all about good conduct and what is expected of you as a practitioner. So when the GMC investigates a case, they will first of all look to see how serious the matter is. They will consider whether there's any risk to a patient, if it's a clinical concern, and they will obviously be keen to assess how the professional has responded. So the next piece of advice is absolutely deal with the GMC with professionalism and courtesy, and anything they ask of you, you must address immediately. So from the very outset of information they request from you, which might include things like your current employment, whether you're doing any additional work at the same time, whether you're doing any private work, what your previous work history is. It's essential that all of these matters are dealt with promptly, because the fact of not responding to the regulator can in fact be a regulatory issue in itself. So it goes back to reach out, get help with this. You're not in this alone. Seek professional advice in the very early days of your investigation, and absolutely be represented. If there is a significant risk that the GMC is concerned about, they may refer the case to the interim orders tribunal. So, for example, if they've got a concern which is related to practitioner health, that's another area that the GMC concerns itself with. You may be asked, for example, to undertake a health assessment. If there's an English language concern, again, an assessment might be an appropriate remedy in that particular case. So you have an opportunity early on, really, to shape the investigation and to comment in the best way possible. In terms of if there is to be an interim orders tribunal, they will consider whether the doctor's registration should be restricted at that stage and on an interim basis while the wider investigation takes place. Now, they do have the power to suspend, or they could impose conditions for a period of up to 18 months, with the order reviewed every 6 months. So the sort of matters that we see coming before the interim orders tribunal are things such as poor performance, allegation of a sexual nature, health concerns, and interestingly, and something that is very much on the increase of late because of the political climate we find ourselves in, are doctor opinions. So one has to be careful that if you're using social media, for example, and if you are politicized in nature, then I would always have regard for the fact that whilst it's good to have strong views and political opinions, one must remember that you are regulated and that anything that you're putting out on social media, particularly in these rather strained times, are matters for which you could appear before the regulator. Somebody gave me a very good piece of advice once, which was when you write an email or a social media post, imagine it being read out in a court of law. And I think that's sound advice, really. So it's not to say that you can't have views and you can't join society in expressing concerns, but you have to do so in a way that aligns with the conduct and the privileged position that you find yourselves in as a doctor. So in terms then of the investigation, it is obviously can be an extremely stressful period, particularly if you're fighting a number of cases on different fronts. So as an example of that, in a case involving a doctor who may have had a domestic situation arising at home, that then spills into criminal proceedings. There may then be care proceedings, social services investigation around their children. And then, of course, you've got the both regulatory and employment cases as well. So you can very easily members can very easily find themselves going from a situation of being in practice to then fighting a case on 4 fronts, so whether it be the family courts, criminal courts, social services interventions, the regulator, and of course the employer, whether you're employed by a trust or a health board or you're a partner in a partnership. All of these matters will of course affect their position and will no doubt lead to a workplace investigation as well. So it's crucial, of course, that you are protected and supported during that process by family, by friends, by your professional representation, and also by the support services that can be provided to you via your defence organisation or by us at the BMA and BMA Law. So that is just as a sort of starter, really, in relation to the starting point by the GMC. So cutting to the chase, ensure that you reach out immediately for representation. Don't try and liaise with the GMC yourself. That's why you have indemnity and defence organisations to protect your interest at that point. Following the investigation, there will then be a decision made by the GMC in relation to how the matter proceeds from there. So once the GMC has had the complaint or notification, for example, if it's a criminal conviction, then there is the provisional inquiry and they'll decide and determine if a full investigation is needed. You will then be notified once the investigation stage is completed and they've gathered their evidence and made an assessment, they will then send you what's known as a Rule 7 letter, and you'll have an opportunity at that stage you'll have 28 days in which to respond to the allegations. So they are draft allegations at that stage. Quite often we advise members not to respond at that stage, and sometimes we will. It depends on the facts of the case. And then once we've made our decision as to whether we're going to respond to the allegations at that stage or not, the case examiner will then make a decision in the case. And the decisions will either be that there's no further action, there will be a warning. Now, in relation to a warning, that can sometimes be a satisfactory conclusion to more minor matters. So, for example, lots of road traffic, more serious road traffic matters in terms of, for example, drink driving and other health-related matters, as long as the GMC is sure that the practitioner is seeking help and that they are on the road to resolving those issues that led to that offence, then they may issue a warning. And there's lots of other examples where a warning is an appropriate conclusion to a case. In terms of a warning, that remains on your record for 2 years. 1 year of that will be on the public record, but it's certainly a way of avoiding the referral to the MPTS. So that's one way that the case examiners could conclude their investigation. They may agree undertakings with the doctor. So, for example, that could include supervision. So if there are low-level clinical concerns, that can be quite easily resolved by agreed undertakings between the parties. Again, that's often a good way to bring proceedings to an end, because let's face it, doctors, like any of us, are human beings, and there are times in life where things don't necessarily go the way we had hoped them to go, and the wheels can come off. And in fairness to the GMC, they do understand that. They do understand that that can happen in life. So, there are often very sensible remedies to conclude matters. But if the concerns are serious, sufficiently serious, then there will be a referral to the Medical Practitioners Tribunal Service in Manchester. Now, just before I come on to that, there is an opportunity during the seminar to ask questions, which are being, Sabs very kindly is feeding these through to me, which I will come to once I complete the presentation. And if you do have any questions that you wish to ask, please do keep sending them in. If I can't get round to everybody, I appreciate people are on their lunch break, so time is limited, but I can come back to you about that in due course. So in terms then of the Medical Practitioners Tribunal, that is where the tribunal will hold a hearing to consider and determine whether your fitness to practice is impaired in any way. So clearly, one does not want a referral to the MPTS during their career, but it is also an opportunity to put your defence, if you have a defence, to the case against you. And in terms of the preparation for that, it's taking about a year for cases to be from the case examiner's decision to get to the MPTS. And in that time, we would then be advising the member in relation to how best to approach the case. If it is a case that the member wishes to defend, we obviously then set out drafting a statement, obtaining witness statements, obtaining medical records if necessary, having a conference with counsel. We instruct a panel of barristers who attend at the hearing at the MPTS in Manchester, and there will be meetings with counsel in order to prepare that case. There are matters where admissions are necessary, and the GMC and the MPTS will expect practitioners to dive into their soul in relation to these matters and really consider the allegations very seriously, because it's a very different type of tribunal or court, in the sense that what the MPTS are most concerned about is some confidence that the practitioner is going to be returning to practice and ultimately a safe practitioner and a practitioner with whom patients and the wider public can have sufficient confidence in, that they are not in any way a embarrassment to the profession. And that is ultimately the, regardless of what's in the good medical practice, what the GMC and the MPTS are primarily concerned about is the confidence that the public and patients have within our medical profession, both state provision and also within the private sector. So we would have that conversation. There will be a number of administrative hearings during that process, which you as members would not necessarily need to concern yourself with. That would be dealt with by your lawyers. The tribunal then can last however long the allegations are, really. Clearly, if a member is admitting the case against them, then the stages are reduced. So in terms of the tribunal hearing itself, there's the first part of the tribunal is to determine the allegations and whether or not the allegations are found. Now, if we are admitting the case, then of course that stage one then is already dealt with. And then in terms of stage two will be whether or not, because of, by virtue of the admissions or finding of a fault in part one, is your practice, are you fit to practice, will be stage two of that. Is it impaired? If at stage two they determine that your fitness to practice is impaired, then the final stage then will be in respect of sanction. And how one deals with the case will obviously ultimately affect sanctions. So this is why it's crucial, and I keep labouring the point, it's essential that you have representation, because that will help enormously in relation to the range of sanctions that would be imposed. And they again can range from a warning right the way through to erasure from the medical register, and that would be for a period of 5 years before you could reapply. And within that, then you also have the option of conditions and suspension. So that's the range of sanctions that are available, and it's very much how the case has been presented will determine whether or not your fitness to practice has been impaired and what the sanction is. Now, you can also have a case which is referred to the Medical Practitioners Tribunal, where you may admit the allegations, but the MPTS are satisfied, the panel is satisfied that actually you have properly remediated and reflected and shown remorse in relation to the matter. And they may adjudicate that your fitness to practice is not actually impaired, even though you've made admissions to the allegations, that your fitness to practice is not impaired. And actually a warning could be a suitable remedy, even at the end of the Medical Practitioners Tribunal. So a referral to the MPTS does not necessarily mean that they're going to be more stiffer sanctions, because there are cases where fitness to practice has not been impaired. So just again, to give you that confidence that the process is not black and white. What is important, essential, right throughout these proceedings, is that you are advised in relation to, if you have admitted the allegations, that you then go through an exercise of remediation and insight. You express remorse, and that you undertake courses relevant to the allegations that you're facing. So, for example, if they're clinical matters, then clearly it's important that your clinical standards are addressed and that they are looked at, and that you are provided with further training, that you undertake courses. Similarly, if the allegations against you are of a conduct or probity matter, then we have to satisfy the tribunal that you have understood that your conduct as a doctor has to align with good medical practice, and that you have taken steps to undertake relevant courses in relation to what it means to be a doctor and how that aligns with good medical practice in terms of ethics and probity. So these are all the things we'd be advising you to do. We would seek references. The GMC and the MPTS particularly like references from your both peer and superiors within the medical profession. For example, your responsible officer, clinical lead. These are all the types of people we would want to obtain references from. They can be from other people outside of your working life, but we tend to find that clinicians, particularly who are perhaps senior to you, they are people who we would wish to speak with as part and parcel of that process. So that's, if you like, some information as to what the GMC and MPTS procedure is. So I've discussed about remorse, insight, and remediation. It's a difficult process, actually, for us to look within ourselves, but that is absolutely what is expected of us, as to give an explanation to the MPTS and the GMC as to what has happened here, what has led to this moment. So in any of those allegations, for example, if it's a health concern, there may have been a number of issues in your personal life that has led to this moment in your life, which can be explained to the GMC and MPTS, and it's giving that assurance that this is a moment in your life where things haven't necessarily gone right, but you have tackled it, you have shown remorse for your actions, you have demonstrated insight as to why that behavior was unacceptable when you are a regulated doctor, and in terms of remediation, showing and demonstrating that you have undertaken sufficient training and understand what your priorities are as a doctor, and giving that absolute assurance to the tribunal that nothing like this will ever happen again. And that can take many forms, and we will assist you in relation to that. And we had one member who actually now lectures on this and goes to hospitals around the country and talks about his experience and talks about how we can all as professionals lose sight of those first principles of being a professional. And it's very important, I think, whatever stage of career we're at, is just to go back and remind ourselves what is expected of us in terms of our conduct. Because it's very easy in a busy life to forget that sometimes. And the conversation I often have with young doctors and medical students is that it's essential that they understand that your behavior and conduct, not only in work but outside of work, can lead to GMC investigations. So that's also critically important, that if you're a practitioner 24/7 in your private life as well as your professional life. And that again is something which we try and get that message to new entrants into the profession, so they understand that your behavior, your conduct is also always under scrutiny. But of course, it's not trying to get people to live like saints, but they need to understand that if you're regulated, then more is expected of you. In terms of preparing a statement, we will have a discussion with you in relation to that, particularly around the Rule 7 point, where you're not obliged to provide any comment on the allegations at that point. We can if we deem it necessary and we feel it's going to further your case. But there can be a pitfall in statements, particularly, for example, if you are in multiple proceedings at the same time. So, for example, if you're facing a workplace investigation as well as a GMC investigation, it's important that your evidence is your evidence and that it chimes, because there are many cases where individual practitioners' evidence changes, and that can be problematic. And often practitioners will submit a statement to the GMC having not sought any advice first of all. And so they don't necessarily paint themselves in a very good light, because it's a knee-jerk reaction. So just be cautious about what goes into the GMC and the tribunal, and that ideally needs to be checked off by your representatives before it goes in. In terms of, as I say, in terms of courses, there's an awful lot available through the BMA, through other online providers. And again, we will steer you in relation to what is relevant for your particular case, because they should of course be targeted for your allegations. We don't want you undertaking courses that have no real connection with the case against you. So that's just another point worth making. I've mentioned about we would want independent people to comment on you as a practitioner and as a person. So we would look for your responsible officers, supervisors, clinical leads, but also friends, family, and co-workers. You know, if you're involved in local sports clubs, for example, or music clubs, or you do things in the community, then that all goes to showing your roundedness as an individual. So all of that evidence will be collated. We would submit all of that into the tribunal in advance of the hearing, and that would all be essential to provide evidence about your good characters. And a requirement for us is that we have to inform the witness as to what the case is against you, because the MPTS would expect the individual, if you're giving a statement in support of somebody, they would need to know what the case is against you. Quite often we will ask the witness to come and give evidence at the tribunal. They can do that either by video link or in person. Equally, as your case in front of the medical practitioners tribunal, you can choose, you have the option whether to appear in front of the tribunal in Manchester or via video link. We encourage people to attend, but understand, of course, that sometimes that's not always practical, particularly if you live in parts of the country that are further afield from Manchester. So yeah, in terms of impairment, if your fitness practice is impaired and you receive a sanction, it's not the end of the road. You do have an option to appeal that decision to the court, to the High Court. Again, we would give you advice in relation to that. One has to be very careful about appeals, because the whole exercise that you're involved with in terms of the GMC and the MPTS is about remediation, and it's about showing that you've got insight. Now, there is an argument to say if you then appeal the decision, are you properly showing remediation and insight? So we'd have to look at that on a case-by-case basis. The drawback of an appeal is that if you're unsuccessful, you are liable for all of your own legal costs, but also the costs of the GMC. So we are very careful about appeals, and we will advise you accordingly on that route. So that, as I say, it's in the High Court and it can be extremely expensive. So it's something that we don't encourage terribly often, I have to say. And just to reiterate, I'll give you that information again in respect, because you may not have had good time to take it down, but we do have the BMA support service available to you, and their number is 020-7383-6707. And I'd encourage you, if you're ever in this situation, to reach out to them for support. Now, in terms of this seminar, it's all about, encouraging people to ensure they access support, whether you're through the BMA or BMA Law or through another provider. But what happens early on in a process can often affect the entirety of the proceedings. And any lawyer will tell you the same thing, that, for example, in criminal proceedings, if you're ever arrested for an offence and you are offered the services of a solicitor, which is free of charge in the police station, it's not means tested. Always seek advice from a solicitor. There is and even if you can't get hold of your defence organisation, there's a duty solicitor scheme in this country, which is very good. There's often a misnomer about the duty solicitor scheme because people feel they're police solicitors. They're not. They are local firms who happen to be on the duty rotas, and it's absolutely crucial that you have a solicitor with you in the police station, because again, anything that's said or not isn't said during a police interview can impact not only criminal proceedings, but it will have a spillover to potentially family proceedings. If you're involved in family proceedings, it could have a spillover to the GMC and, of course, to your workplace case as well. So, look, I mean, the way I'm presenting this, I sound like the prophet of doom, and that's not meant to be my desire today, because most cases actually resolve very amicably, and very, very few doctors end up being erased from practice. So I hope that gives you some encouragement, and that you can reach out to us at any time. I'm going now to have a look at some of the questions that you've got. Somebody's asked about a doctor being entitled to full pay from work whilst on an MPTS suspension. My experience is that most employers will suspend on full pay. There isn't an obligation on an employer to keep you on during those proceedings. They can undertake a workplace investigation, and if they deem the case to be sufficiently serious, they can force it down the disciplinary route at work, and you can be dismissed. So there's no law, I'm afraid, to stop your employer dismissing you even before your GMC proceedings are over. But I've got to say, from my experience, most are kept on full pay. So I hope that answers that question for you. Right, going to the next one. Yeah, in terms of BMA law, we are a separate law firm. We fall under the umbrella of the BMA, but we are independent of them, and we are a separate legal entity to them. We're a not-for-profit organisation, and the services that we offer are different to the BMA because they're non-member services. So we do offer preferred rates. They are reduced rates for BMA members, and you would be entitled to independent legal advice, as I say, as a separate entity to the BMA. So I hope that helps you with that question. I'm asked a lot about, there is a concern in relation to the GMC and about those practitioners who are minority. Interestingly, I get this question a lot, and there is a concern about ethnic minorities and GMC outcome decisions. I share your concern, because the data is there, it's available for you to see, and it is a problem. And I know that there have been a number of concerns raised with the GMC about that. So yeah, I am fully aware that there is an issue there, and what I would say is that it is being pressed with the GMC, and I understand there is some political concern about that as well. So, but if you want to have a chat with me about that in more detail, don't hesitate to contact me. And I believe somebody else has just asked the same question. I believe there are stats on it, and if you want me to help you with that, do come back to me, and I'll assist you. Somebody's asked about, when you've got allegations that straddle different areas of practice. That's a really good question. So, for example, if you've got a workplace investigation, that can often be dealt with by a trade union representative or BMA representative. If you find yourself within the criminal arena, you may have a criminal lawyer. And then obviously you've got a regulatory lawyer dealing with the MPTS and the GMC. It's important. Some lawyers do have an overlap. I spent 20 years as a criminal litigation solicitor, so as well as a regulatory lawyer. So lots of lawyers who appear in this area of practice have often been criminal inquest employment lawyers as well. But it's important that you have a lawyer that is catered to your particular case. I mean, for example, I've never practiced family law, and I wouldn't dream of doing, representing a member in relation to family proceedings. So it is important that you have lawyers separately, really, in these proceedings, unless you have a lawyer who is cross-jurisdictional, if you like, who can cover more than one area of practice, and there's no conflict that arises. So, yeah, it's a good question. You need to safeguard yourself in respect of this. Now, somebody has said that they know that employers are using GMC referrals to bring pressure to bear within employment disputes. I think that that's a very interesting point. And what I would say to that is, if it's done without any merit, then I think the GMC will pretty much quickly get rid of it. The other point worth making is that the GMC are often at the end of the line, so they will await the outcome of all other proceedings before they begin the MPTS. So they'll await the criminal. So if somebody is charged with a criminal offence, they'll await the outcome of that criminal offence before they begin the tribunal. That's their usual practice. It's the same with the employer. They'll often allow the employer to make their decision first, and there's sense in that, really, because effectively it does make the task of the GMC much simpler once the other proceedings have ended. Somebody's asking about, do the concerns extend to females as well as ethnic minorities? Not in my sphere of knowledge, I'm afraid. I'm not aware of that. I'm aware of the concerns. It's specifically in relation to ethnic minorities. I've not seen any data or concerns in relation to female doctors, but again, I'm happy if you want to contact me directly to have a look at if there's any stats in relation to that. And in terms of how the GMC can be fairer towards ethnic minority doctors, I think that there seems to be a drive now that like any tribunal or court, it should really reflect society at large. And I know that is very much a concern in relation to ethnic minority doctors. And it is something the GMC is alive to, that they want to ensure that the panels reflect the profession. And I very much welcome that. And that's done as a matter of some urgency. I've been asked if the duty solicitor scheme is available in Scotland as well. I will have to get back to you on that. I'd imagine it is. I believe it is, but Scotland, in terms of criminal law, has a different jurisdiction to England and Wales, and Northern Ireland is separate again. But I can check that for you if you want to. If anybody wants to contact me directly, my email is c.williams@bmalaw.co.uk, c.williams@bmalaw.co.uk, and I'll be delighted to have a look at these points for you. Somebody's asked about the impact of the allegations of my wife from a GMC ruling. If you want, that's quite a specific request. By all means, come back to me on that, because I think you need some specific advice in respect of that. So feel free to email me about that. I know that Kate from BMA is going to be sending out some information after this seminar. So within that, there will be my email address, so you can contact me. Somebody's asked about how the BMA and BMA law work together on complex cases. I mean, we do often, of course, BMA representatives appear in the workplace investigation, and of course, being part of a globally together, even though we're independent to the BMA, we do work with reps to get the best outcomes for members of the BMA. Yes, somebody's asked about the strike off. If you are raised from the MPTS off the register, you're able to, you can reapply after 5 years, is the answer to that question. Somebody's asked about successful appeals against the MPTS. There have been successful appeals in relation to sanction outcomes. So yes, there is evidence of that. It's not to, we don't say not to appeal, but we say we advise caution in relation to an appeal, because you have to be sure you're going to be you've got at least 50% chance of success. Somebody's asked about the yardstick of remorse, remediation, insight. That's a really good question, because I don't think there is any yardstick. Our experience is that the more that you do in respect of courses and demonstrating other forms of remediation. For example, I mentioned to you about the practitioner who had decided to talk about his experience to fellow practitioners. I can tell you that went down extremely well with the MPTS, and the decision at that point was that that individual's fitness to practice was not impaired. I think they were terribly impressed by the amount of work that this individual had done in terms of demonstrating absolutely that they had fully learnt their mistake, that learnt the lessons of their mistake, and that they had taken so much time to show proper remediation and insight. Okay. Somebody said about submitting evidence for a doctor referred to the MPTS. Would there be repercussions? I would hope not. I mean, I've not heard of that. I've not known any witnesses that we've relied upon to then have had any repercussions in relation to that. So, not from our experience. So, I think if somebody has reached out to you for support, it's a matter for you. You're not compelled to be a witness to these proceedings. It is a matter that you would have to consider carefully. But if it's something you feel that you wanted to do, then yes, I think that you should be encouraged to do so, and to protect your fellow practitioner if you feel sufficiently supportive of them. I should also add, of course, that the profession, there's an obligation on the profession as well to raise concerns, to raise regulatory concerns. Again, even though that's not a pleasant thing to do, one has to be cautious that it's important not to turn a blind eye to poor practice, because what has happened is that when eventually individuals refer to the GMC, they'll want to know, how this has not taken place sooner, and whether there are practitioners who, when they had an opportunity to do so, they failed to do. So that's something else just to sort of make you aware of, that you can have your conduct looked at for omissions as well. But just to make you aware of that, it's all about both protecting the profession, but protecting others within that profession who there may be concerns about. Somebody said, how do you find out if a complaint of misconduct is made against you to the GMC? The GMC, after their initial investigation, they would contact you. So you would know directly from the GMC themselves. Somebody's asked about if you're a member of both the BMA and a medical defence organisation, would the BMA Law Defence Union tend to legally support the person through a GMC and MPTS process? It depends really on the terms of your membership. As I say, quite often, some defence organisations will not involve themselves in non-clinical matters. So you would have to check the terms of your membership, and quite often BMA law is instructed because the individual member doesn't have cover. Okay. Somebody's asked about how long the investigation can take. In our experience, they're quite an efficient organisation. I think it helped that the MPTS was running right through COVID, right through the pandemic, because they were dealing with tribunals remotely. So I think that did help. It tends to be, we're finding from beginning to end up to the end of a MPTS 18 months to 2 years. So it's a long time, but that's where we are in terms of time scale. Yeah, I've been asked some specific case questions, which might be better to come through to me if that's all right, on my email address, if that's all right. Somebody's asked about where a doctor chooses voluntary erasure and then being denied by the GMC. My experience of that is the where the doctor is already within the process, an attempt then is made for voluntary erasure, but their rules will not allow that. So if you're in an investigation stage, any application for erasure would be denied. You can, of course, have your lawyers can have a discussion around that. So, for example, if it's a low level case, and the allegations are deemed to be not serious enough for the MPTS, there could be a discussion around whether or not the practitioner would continue, and that conversation often happens where the individual is about to retire. Somebody said, should I inform the BMA straight away if I've been contacted by the GMC? Yes, if you're obviously you would be a BMA member. Yeah, absolutely contact us immediately once you've heard from them. Somebody's asked if you could decline a warning from the GMC. Yes, you can. You can. I mean, if you feel strongly and under advice from us that you should not accept the warning, then we have refused warnings, and that can go two ways. There can then be no further action against you, or they decide that the only place left for them is to refer to the medical practitioners tribunal. But absolutely, you don't have to accept their offer of a warning. That's a good question. Again, these questions I'm very grateful are still coming through. I think we'll go up to 2 o'clock if that's okay, and then anything else I can respond to you directly. Yeah, it's interesting. Saying that doctors not receiving updates after litigation claims are settled. I mean, quite often you'll find that trusts, for example, will settle cases on a no liability basis, and that's probably the reason why they don't share anything further with the individual practitioners. Somebody's asked about if you're under investigation for an offence outside of work, but no charges have been made, would the GMC likely to see you before? No, they'll generally await the outcome, unfortunately, which can be very difficult for individuals because they'll be often suspended from work whilst they await for example, the police outcome. And quite often, if it's a case that involves forensic examination of phones or computers, the system is overwhelmed with work, and it can take 12 months just to have your devices back. So it's extremely frustrating, and that's when if you had a good criminal litigation lawyer, they can keep on at the police and try to push your case to the top of the queue, because obviously of all the other aspects involved in your case. Very good question about how can you show remediation following a false allegation. Well, in that situation, you would be contesting the case. So if the charge is put to you by the GMC, then you would not remediate in a sense because you do not agree with the allegations. So what you're effectively saying is that I do not have anything to remediate for because I do not agree with what's been put and what's been said about me. And that becomes then you're defending the case. It becomes a very different case to the most types of cases that we have, which is about acceptance and remediation. But I'm not saying for one moment that those are typical of all cases, because there are cases where the case put against the member is something that the member wishes to challenge. So you're absolutely right. At that point, there would be no discussion around remediation and insight because we do not agree with those charges. Corporate manslaughter investigations. I, if you're accused in that type of case, and the police wish to interview you, then it's critical that you have legal representation during those interviews, and that is available to you from the duty solicitor scheme. If or you can, of course, have your own solicitor with you in interview. I should add as well that the duty solicitor scheme, the interview is free of charge, and you have an ongoing right to legal representation. So, for example, if you attend the interview and you decide midway through the process that you want to have a representative, that you're entitled to that at any time. So that is important. The family courts are somewhat different. Funding is very different around the family courts, and as I say, you may have social services involvement as well. But you would need to speak to a family practitioner. Again, those are matters that we can assist you with. We do have panel firms who can assist us, and we can signpost you in that right direction. Somebody's asked, can you decline if you're called as a witness for somebody at the MPTS? You can. You don't have to appear as a witness. The situation becomes more complicated once you've signed a statement. So I think if you are asked to be a witness, then you need to consider whether or not you want to do it, because once that statement is signed, technically you could then be forced to appear. But as most lawyers will tell you, you would not call a reluctant witness. So I think if you are approached to be a witness on behalf of somebody, think very, very carefully about that at first. Somebody's asked me about clinical negligence issues. What tends to happen from my experience is that most clinical negligence issues are covered within the confines of your employment contract in terms of your liability. So that from, as I say, from my own experience, that's normally the trust that would assist you in relation to that. It's different, of course, if it's a private matter. And then I would encourage you to go to your indemnity provider in relation to that. So we're coming up to 2 o'clock. There are a number of questions that are still coming through. So I will have a copy of these. My email address is c.williams@bmalaw.co.uk. And you're very welcome to contact me on any of the issues that have been discussed today. It has been a rather a whistle-stop tour of the GMC and the MPTS proceedings. I hope it's been of some assistance. And of course, you are very welcome to contact me directly for any specific concerns or advice that you might need. So thank you very much for joining us today. And I enjoy the rest of the afternoon. Thank you very much.